presenting in Italy.
And presenting in Italy, yes. So thanks so much, Thomas. Now I can't actually close this and switch my one to another. I may need a computer helper, Margaret.
Kazakhstan has took over the mobile.
They have, yes. So
Like this.
so there's one of these little ones.
Minimize the window, and you have your file on the desktop or
It's already here. I think it's that one. No, not that one.
there.
This looks promising. Yep, that's it. Thank you. Well, ladies and gentlemen, I'm going to comment on the two addresses we've just heard, and the form of my comment is in what's known as an incubation form. That is, it is an article that I propose to write, and I want to present the hypotheses in the article to this audience in the hope that you will give me useful comments. I'll finish up with a few specific questions. Now, this particular technique is one that I came across in April at a meeting of the Critical Tax Group in St. Louis. And it seemed to me that the way that group of about 30 United States professors worked was very productive. They commented on each other's proposals. They had very short sessions that they called incubation sessions, and they were able to help one another in a very productive manner. So what I'll try and do is illustrate how what I'm talking about reflects in particular what Stephen addressed. Now, I have a proposed article that I call Form, an Exogenous Element in Taxation Cases. In going through the article, I'm going to limit myself to business profits. If I were doing this more elaborately, I would list for you now the documents that I would circulate. So I mentioned that as a helpful point. And I'll finish up with some comments and questions. Now, the legal philosopher Salmond explained that formalism means the tendency to attribute undue importance to form as opposed to substance, and to exalt the immaterial to the level of the material. And he explained that whenever the importance of a thing in law is greater than its importance in fact, we have a legal formality. Now, the thesis of my proposed article is that the operation of form is different in tax law from the way it works in general law. We assume that it's the same, but if we analyse what Stephen told us, we may come to the conclusion that in fact it's different. Now, form in general law is usually justified by the policy of the area of law in question, whereas form in tax law is imported from the general law, and there's no necessary relationship to the policy of the tax law that we're talking about. And the result is that in tax law, form applies in a much more arbitrary fashion than it does in general law. And we've gone and lost this.
The computer disagrees with you.
Yeah. There's a corollary. There's a corollary. Same problem, eh? A corollary to what I've just said, and that is that if we analyse judicial reasoning, we see that certain facts are regarded as material, certain facts are regarded as not material. And if we distinguish two cases, the cases tend to be distinguished on the basis of what facts are material and what facts are not material. Now, if we look at a case in the general law, we'll find that facts that the general law regards as material to distinguish two cases usually reflect the policy of the law in question. But in tax law, the facts that distinguish two cases are often completely arbitrary. Now, the basic law or reason for this is that tax law is about business profits, that it's about economic facts. But the tools and reasoning that we use in tax law are legal norms. And the problem is that tax law defines profits, not in economic terms. Tax law defines profits in terms of legal norms. Now, take, for example, the treatment of corporations. The general law recognises the corporate form, and the general law will treat even the formality of a one shareholder company as a legal person. That was not always understood in the common law, not until the famous House of Lords case of Salomon against Salomon, which was a one-man company that had financed itself by debt from the shareholder. And so the shareholder was able to prevail over external creditors. But the House of Lords said, that's all right.
So John, the 5 was here or desktop or... Oh, she would.
Yep. And there are similar sorts of cases that have gone before the Privy Council. The Privy Council is equivalent to the House of Lords and dealt with appeals from the Commonwealth. House of Lords dealt with appeals from the United Kingdom. And in the famous case of Lee against Lee's Air Farming, we had again a one-man company that was involved, thank you very much, in Lee against Lee's Air Farming was involved in aerial top dressing, very dangerous activity. The question is, can Mr. Lee, who manages to kill himself while top dressing from his aircraft, can his widow claim against the company on the basis of Lee being an employee of the company? And the law says yes, she can, even though there was really no difference in substance between Mr. Lee and the company. There was just one man, one aeroplane, one death, one widow. But you put a corporation in and they are separate. Now, we don't complain about that sort of result. We say, well, those two cases, Salomon and Lee's Air Farming, they are hard cases. They are unfortunate for the creditors of the company. But nevertheless, the whole purpose of the corporate form is to separate ownership of a company from its management. And that is the policy of company law, and that's why we have this law, and we won't complain if there are some hard cases at the boundary. But what happens if we apply that theory to a tax case? Take the English case of Inland Revenue Commissioners and Sanson, again a one shareholder company where the company retains profits. It does not deliver or distribute dividends. Instead of distributing dividends, it lends money to its shareholders. Now, if there's only one shareholder, then from his point of view, it doesn't matter whether the money comes out of the company in the form of a loan or as a dividend. But coming out as a loan, there's no super tax on the dividend, but if the profit had come out as a dividend, there would have been tax. And so the Commissioner challenges this arrangement and the Commissioner loses. Now, the position, I suggest, is different, because as far as tax law is concerned, the policy of tax law is to try to tax the individual, in this case, Mr. Sanson. But Sansom puts up a company between him and the Commissioner, and the company acts as a shield in the same way as the company acts as a shield in commercial law. Now, if we look at the policy of commercial law, it is to facilitate commerce. And in facilitating commerce, commercial law invents the doctrine of limited liability, the doctrine of permanent succession that we have in companies, and for those sorts of reasons, it doesn't trouble us that cases like Lee against Lee's Air Farming come along. But the policy of tax law is to tax people proportionately, roughly, according to their ability to pay, at least. And that's why we have income tax instead of a poll tax, because income tax can tax people according to their ability to pay. Sometimes not necessarily proportionately, sometimes maybe progressively. But the whole point of tax law is that it focuses on ability to pay of people. There's no such thing as ability to pay of a company, because of course if we think a company is too rich, we can just divide it into 100 companies and it doesn't seem to be so rich anymore. That is a nonsensical result. So the other point is that there's no fundamental policy of tax law to tax a company. When you think of it, in the end a company is no more than a filing cabinet or lots of filing cabinets full of documents. So why do we tax companies? Well, we tax companies as a mechanism. It's not a fundamental policy. We tax companies because if we did not tax companies, the profits would sit in the company and not be taxed, as the profits sat in the case of the company in the case of Sansom. So we tax companies as a proxy for taxing shareholders, not as a fundamental policy. And the problem, when we think of it, is that the formality of corporate form promotes the policy of commercial law, but it interferes with the policy of tax law. And that's an example of what I mean when I say that form is an exogenous element in tax cases. It's an endogenous element in commercial cases, because the kinds of form that we look at are designed to promote commercial activity. But they're not designed to help tax law at all. They just come along because they're present already. And the Commissioner must make the best of the position. And the result is that we have all sorts of very odd reasons that in tax cases where judges grasp onto facts that they think might be material but aren't really, because they do not have any relationship to the business profits that we're talking about. Now, the case that Stephen told us about, Cottage Savings, very good example, because from the point of view of commercial law, the difference between the different kinds of companies and the different kinds of mortgages and all the different lenders, that seems to be pretty important. But from the point of view of the bank, Cottage Savings, those different mortgages were fungible. If Cottage Savings had been a dealer in sugar and they'd swap one lot of sugar for another lot of sugar, we would think, well, that must be treated as a wash sale. But because they're not a dealer in sugar, but they are a lender on house mortgages, we think to ourselves, well, we can't treat people as if they are fungible like sugar. We must treat them as separate individuals. Therefore, we must regard what Cottage Savings did as a realisation. Whereas, of course, from the point of view of Cottage Savings, the last thing that they wanted to do was to effect an economic realisation. They wanted to maintain the same mortgage portfolio they had in the first place, but recognise their losses if they could. The basis of Stephen's paper is that tax law says you can't recognise losses unless they're realised. And the company created what it said was a realisation. Well, from a legalistic point of view, it was a realisation. But from the point of view of the policy of tax law, it was not a realisation at all. It was no more a realisation than the realisation that claimed to occur in Higgins and Smith. And just to repeat it myself a little, it seems to me that the distinguishing fact that we take that distinguishes Higgins and Smith from cottage savings is that in Higgins and Smith, the taxpayer maintained control of the company, whereas in cottage savings, the taxpayer swapped one lot of mortgages from another and was not the controller of the borrowers. Now that's an important matter for commercial law, but it's not an important matter for business law. From the point of view, to repeat myself, all these mortgage borrowers were fungible just as much as if they'd been pork bellies, but they were in fact humans. And so that's what I mean by way of an example of tax law seizing upon facts that are not really material for tax law. Now, in developing this article, may I ask for some help? I'd be interested if people can think of good examples of formalities that come up in other areas of law where we can demonstrate that the formality that the law adopts is relevant to the policy of the law. So I'm not talking about tax law, I'm talking about other areas of law where we have one case distinguished from another. And similarly, examples of material facts that have been seized upon in other cases. And then we often find in the common law anyway, lines of cases that show that earlier cases were mistaken or framed too broadly. And I'd be interested in examples of, again, non-tax lines of cases. One that occurred to me that I remember somewhat dimly is the American cases that compare the duties of hotel keepers with the duties of guards on trains who are looking after people in sleeping compartments. Hotel keepers have a duty to keep thieves away from their guests, but guards on trains either do or don't, I can't remember. And there is an interesting line of cases that is taught to first-year American law students that illustrates the materiality or non-materiality of the fact that the courts seize on. And if people can suggest fruitful areas of comparison, I'd be interested in that. And finally, a very specific question that I'd like to put to the Americans here. This case of Salomon and Salomon is the foundation corporate law case in the British Commonwealth that says essentially when the company law statute says we will create by statute limited liability, perpetual succession, independent personality, we really mean it. And that policy of that statute does apply even to one-man companies. Now, I haven't been able to find whether there is an equivalent United States case. The closest I can find is a tax case, Moline Properties, but I'm looking for a case that it doesn't relate to tax, it just relates to corporations. Somebody suggested to me the Dartmouth trustees of Dartmouth College case, but that in fact establishes the opposite. The trustees of Dartmouth College is an early 19th century case that says, yes, there is such a thing as a corporation and we'll recognise it as having a separate personality. That's fine, and in that particular case it did make sense to recognise Dartmouth College as a separate legal person. But what I'm looking for is a leading American case that says, even though it doesn't really make much sense to recognise this one individual person as a separate person from his wholly owned company, we're going to do it, because that is the policy of commercial law. So those are the questions that I would hope to ask, and I hope that in making these comments I've also demonstrated a fairly elaborate incubation session. Some of the sessions I saw in St. Louis were as elaborate as this, others were much less elaborate, people just suggesting a few ideas and saying, what can you do to help? So it'd be unfair if I were to take over all the response to the questions, so I'm sure there are other questions that people could give also to Thomas and to Stephen, and I hope that some questions and comments might reflect on all three of the addresses that we've just heard. So who can start? Yes.
Well, I guess I have a couple of observations.